Welcome to literary and jury charge practice. We'll start off with some jury charge. Ready? Here we go. Plaintiff Dr. Michelle Taylor claims that defendant Texas Southern University discriminated against her because of her sex by paying her a lower wage for performing work requiring substantially equal skill, effort, and responsibility as work performed by Mr. Matthews and his successor, Mr. Derek Wilson, males who have held the position of Assistant Dean for Administrative Services in the Thurgood Marshall School of Law, to whom she compares herself, and who, in that job, were paid more than plaintiff. The basis for Dr. Taylor's claim is the Equal Pay Act found in Title 39 of the United States Code at Section 206D. Section 206D in relevant part says, no employer having employees subject to any provisions of this section shall discriminate within any establishment in which such employees are employed between employees on the basis of sex by paying wages to employees in such establishment at a rate less than the rate at which the establishment pays wages to employees of the opposite sex in said establishment for equal work on jobs, the performance of which requires equal skill, effort, and responsibility, and which are performed under similar working conditions. In considering the elements of the Equal Pay Act and reading the instructions and answering the interrogatories that follow, the following definitions apply. Wages. The term wages includes all forms of compensation, including fringe benefits. Equal. The term equal as used in the Equal Pay Act does not mean identical, but substantially equal. Equal work. The plaintiff must prove that she was employed by the defendant doing equal work on a job, the performance of which requires equal skill, effort, and responsibility. in considering whether work on jobs is equal, you should consider whether the performance of those jobs requires about equal skill, effort, and responsibility. In substantial or minor differences in the skill, effort, or responsibility requirements of particular jobs should be ignored. Equal skill. In considering whether the jobs in question require equal skill, you should consider factors such as the experience, training, education, and ability, and these factors should be measured in terms of the performance requirements of the job. If an employee must have about the same skill in order to perform either of two jobs, the jobs will qualify under the Equal Pay Act as jobs the performance of which requires equal skill, even though the employee in one of the jobs may not exercise the required skill as often or during as much of his or her working time as the employee in the other job. Possession of a skill not needed to meet the requirements of the job cannot be considered in making a determination regarding equality of skill. Equal effort. In considering whether the jobs in question require equal effort, you should consider the amount of physical or mental activity needed for the performance of the job. Jobs may require equal effort in their performance, even though the effort may be exerted in different ways. Where substantial differences exist, however, in the amount or degree of effort required to perform the jobs, the equal pay standard cannot apply, even though the jobs may be equal in all other respects. Similarly, jobs do not require equal effort, even though they require most of the same routine duties. If one job involves other additional tasks that require extra effort and that consume a significant amount of time of about all those doing that job. we'll take a little break here from jury charge and try some literary practice. We'll get back to the article we had started on what to do with those old steno machines. Ready? Here we go. The A to Z program is what prompted Wisconsin to request donations of machines as a means of trying to increase the number of students in the court reporting profession. The only way this program is successful is by asking the reporters to donate their older models to the students, she adds. To date, WCRA members have hosted 2 A to Z programs within the state and have a third planned for the fall. Pontek notes, donating old machines to court reporting schools can also help offset tuition expenses for students. In some cases, donating a machine can be used as a tax deduction. When I decide to recycle or toss my steno machine, I give it to a court reporting student, says Laura Lynn Murphy, RMR, a freelance court reporter from St. Louis, Missouri. Many of them are renting a machine. I like to think that if they don't have the rent to pay, they will be more inclined to join Missouri Court Reporting Association or perhaps NCRA as a student because they have to pay dues to join, says Murphy. If there isn't a need from a student, I donate the steno machine to Rankin Technical College. The students there are learning how machines work, and when they tear them down, hopefully learn the workings. I also give them old dictaphones or digital equipment, anything that would help their training and not go into landfills, she adds. Murphy also suggests offering an old machine to companies that sell new ones in exchange for credit toward a new purchase. Many times, she notes, companies will use the old machines for repair parts. Donating an old machine to a student is invaluable, according to Kelly Moran's CRI, program manager and faculty at a community college captioning and court reporting program in Ohio. These machines are distributed to students in need, and it can sometimes mean a difference as to whether they can begin the program or not. Take a break, get back to that article. For now, let's try some more jury charge practice. Ready? Here we go. Equal responsibility. In considering whether the jobs in question require equal responsibility, you should consider the degree of accountability required when performing the job. Also, the importance of the job duties and the degree of authority delegated to the employee. Working conditions. The term working conditions, as used in the Equal Pay Act, encompasses two factors. One, surroundings, which concern the nature and character of the area in which the job is performed, including considerations of the elements to which employees may be exposed, and the intensity and frequency of those elements, and two, hazards, which take into account physical hazards sometimes encountered, their frequency, and the severity of the injury that they might cause. To prevail on her claim under the Equal Pay Act in this case, plaintiff must prove by a preponderance of the evidence that she was discriminated against in her pay on the basis of sex by showing each of the following. 1. Plaintiff was employed by defendant doing almost equal work on a job or jobs the performance of which requires about equal skill, effort, and responsibility as jobs held by members of the opposite sex. 2. The job or jobs are performed under similar working conditions. And 3. Defendant paid to plaintiff a lower wage than members of the opposite sex doing equal work. If you determine that plaintiff has failed to prove any of these 3 elements, your verdict must be for defendant. And we will stop there, and that will conclude our literary and jury charge practice.